So there's a side issue really that goes back to separate and apart from starting a business, dealing with key incentives that you might want to provide to good employees or to existing owners who begin to contribute more to the business.
I left something out. Let me go back here. There's one thing I just didn't mention, which is warrants. This is a private equity issue. We don't see this with individuals where they have warrants. But if you're making a private equity investment, a private equity firm makes an investment, they will sometimes get warrants instead of a buyout, which allow them to say, essentially, if you don't buy me out, I will convert my stock to debt and then demand essentially payment. So it's a convertible type of situation. But again, we don't see that with individuals, high net worth individuals making investments, but you see it if it's a company investment or a private equity firm, then we've seen use of warrants is another exit strategy planning device. What Jason was referring to here was how many of you have some form or are contemplating putting some form of an employee stock option plan in place at the company? Just a few. Well, we deal with owners on the majority side who want to incentivize employees, key employees. And so they'll talk about giving equity. And I will just say as a general statement, we are not proponents of giving equity for incentive, for the reasons that I discussed earlier, which are you're giving breach of fiduciary duty rights, you're giving books and records rights, and if you are an owner or you're working with folks at the business who are owners and they've built this business, there's an intrinsic belief that the holding of this ownership interest is valuable. To the employee who's holding stock or a limited partnership interest and they get nothing from it on a current return basis, it doesn't have the same intrinsic value. What they want is cash. So how do you actually incentivize them and put cash in their pocket but not give them the rights of an equity owner? You use what are called SARs, which are stock appreciation rights, or you use phantom stock, or you use some sort of a contractual right that you give to the minority owner, and they're holding a contract right that gives them no rights of equity, no rights to books and records, no fiduciary duties owed to them. But the formula that applies, it can be tied to earnings, it can be tied to revenues. There's lots of different ways to structure the formula. But at the end of the day, what they get is they get money in their pocket if certain objectives are achieved. And here's a key part to it. If you hold equity, you're waiting for a liquidity event, typically to cash out. If you're holding a stock appreciation right or phantom stock, you're getting a current return and you can influence the amount of the return. Meaning, if you hit those metrics, you get more money. So you actually are accomplishing to a greater degree what you're attempting to by incentivizing employees to give them something that they have some control over, that they will ultimately put more money in their pocket if they achieve this and they can contribute to that. There was a question back there? Yes, sir.
Yeah, isn't there a negative with phantom stock from an individual who would benefit from that, and the fact that you only get ordinary gains on that stock versus the other option of stock options and et cetera, that you have capital gain opportunities?
Absolutely. So the question, let me repeat it, isn't it a disincentive because when you get contractual payments, they're taxed at ordinary income versus if you have a stock or stock right, you're going to be taxed on a capital gains basis? Absolutely true on tax, except that if you're talking about a liquidity event happening, yes, but if it never happens or they've been holding this stock for a long period of time, it's been 10 years and they've never gotten anything, would they have rather have gotten money? Yes, they were taxed on it, but they've got something in the interim. The way to address that question is if the person says, yeah, but if the company sells, I don't get anything, is no, you put it in the formula that there's another kicker, meaning you get current return and current payments, but at the end of the day, if the company sells under a contract, you get more money. Now, you wouldn't get it. It would be paid to you and you'd be taxed on it as ordinary income rather than capital gain, but you're going to get it. So the question is now or later, pay me now or pay me later. Most people want the money now, even if they're taxed on it on an ordinary income. That's our experience. If you're trying to incentivize someone, telling them in 10 years, maybe it's because I have 3 teenagers at home. It's now, talking to them about what's going to happen in the future. But most of the people we talk with who are individual owners also want, the typical owner of an investment wants a current return and a long-time return. They want both. And the problem with the stock options is that they generally don't have the right to get you a current return. So it's a long-term return situation, but at a better tax. Does that answer your? Okay. So I didn't go through all the issues, but these are the issues that you have as an owner. I say issues. These are the rights that you have if you own stock. You have fiduciary duties that are owed to you. You receive profits on a liquidity event. You get the right to review books and records. That's generally in the corporate organizational documents, but it's under Texas law as well. Both limited partnerships, corporations, you get the right statutorily to review books and records. You can call for votes. You can call for meetings. But you have no right to demand an interim distribution unless you have structured at the beginning a distribution plan or a dividend plan at the outset. Contrast it with contracts. Contracts, payments tied to an earnings formula, no fiduciary duties owed, no right to books and records, no voting rights. We tend, I don't know if this is a concept that really works, but when we have new minority owners, and we represent both sides. We represent, our practice is sort of evenly divided. Half the time we're representing majority owners that controlling the company, and then half the time we're representing minority investors. We look at companies as mini democracies. Meaning, if you're a minority owner, you don't get the right to get your way, but you get due process. You get the right to call meetings, you get the right to put things on the agenda at meetings, you get the right to have discussion of those things at meetings. It's a mini democracy, but you don't, in the minority, in a democracy, the minority doesn't get their way, but they have certain rights. So that's how we sort of look at this is, if you're going to give these rights, if you're the majority owner and you're going to give these rights, you've got to give the due process rights that go along with it. If you give them the contract rights, there's no democracy. They just have whatever rights are under the contract.
So we talked a little bit about corporate prenup planning, and there's some other items that we found that just consistently form the basis of disputes. And in almost every case, when we go back and look, one or more of these things hasn't been followed. And if I were to boil all of this stuff down to a single issue, it has to do with the manner in which the owners take money out of the business. And more often than not, the two areas that sum up a lot of people's grievances when they come in and hire us is, number one is expense reporting, the use of personal expenses, a lake house, everything from a lake house to family vacations, getting expensed through the company in an unequal way. And then
It wasn't a lake house, it was a corporate retreat center.
Oh, that's right. That's right.
Just no retreats have been had yet.
Right. The address is unknown to the other owners. And then another common problem is intercompany transactions. You have a pool of owners over here and a pool of owners over here, one or two common owners, and yet money's being funneled over here to support this business from this business. And these owners are thinking, but I don't own this business. I'm investing in this real estate project. Why are all of our rents propping up your other deadbeat project? And so this kind of stuff, these intercompany transactions, and unfortunately, if they're not accompanied by full disclosure and an opportunity to vote by the disinterested parties in the governing authority, if you have board of directors or you have managers, you're just setting up a future lawsuit and giving somebody a card that they're just going to put in their pocket and say, okay, when we fight later, I'm going to remember that short-term loan you made your other business using our money that you didn't think I would see. And a lot of that comes down to having regular meetings, having clean expense reporting policies, to having timely financials issued, and having discussions on those issues so that major transactions, having no disguised distribution policy so that compensation discussions are had sort of cleanly, because of course in an owner-operated type business you have a distinguishment between bonuses, which can be paid unequally, and shareholder distributions, which are supposed to be paid proportionally. So if I structure all the comp so that all the profits flow out as a bonus to the CEO, then the other owners are thinking, wait, why are you getting everything as a bonus? That's just a distribution to you of which I get nothing. That's another common source of disagreement. And then in terms of resolving these things, you have to make a decision on the front end whether or not you want to invoke some kind of arbitration process. I mean, your default metric is going to be the courts, which are, generally speaking, expensive, but you get all your rights. And so you'll get the full power of due process and Texas law if you go the default route. However, it tends to be very slow and very expensive. Now, I have to talk a little about arbitration, because I think that the default provisions that you often see in arbitration clauses really aren't much better. But you can approach the arbitration clause in the same kind of creative way as you approach the other issues.
How many of you have actually participated in an arbitration of any kind? Okay. Well, arbitrations are supposed to be faster, cheaper, and achieve finality. How many of you felt like that happened in your arbitration? That's a much smaller show of hands. And I'm not suggesting to you that an arbitration is a panacea. But I think one of the problems, or a couple of the problems we have addressed in how we approach arbitrations when we put an arbitration provision in the agreement, because we've had some of the same negative experiences. First of all, there's this general view that arbitrators split the baby and you don't get justice. That has not been our experience. If you have a contract, if you're trying to prove fraud in arbitration, we've not had a good experience with that. Fraud and business torts are much harder to convince lawyers, who are your arbitrators, of than contract. But if you have a contract, it has been our experience that arbitrators will enforce the contract. So let's start with number one, which is arbitrators are supposed to be faster. Well, if you don't have any kind of a time frame within your arbitration provision, they don't move fast. So what we have designed is what's called a fast-track arbitration provision, which we have found works very well. What it requires is that the arbitration hearing has to be held within a certain period of time after the arbitration is triggered. 90 days, 120 days, basically from the day the arbitration starts, you know you're going to have a hearing in 90 days. That's one thing that will be very effective to get your arbitration resolved more promptly. Number two, you dictate how much discovery will be permitted. So you don't open the whole can of worms. You limit the scope of discovery, the number of witnesses who can be deposed, the amount of documents that you can get. You force the dispute to be litigated on narrow grounds. So you have a fast-track provision, you have limited scope of discovery, you limit the amount and length of the hearing. You can say it's going to be a 2-day hearing, it's going to be a 3-day hearing. That and those kind of provisions tend to govern much better. We also recommend that you start with a mediation and have a mandatory mediation and force the parties to sit down and mediate the dispute before they go to arbitration so that it allows business heads to hopefully prevail. We're going to get to this in just a minute, but although I said at the outset we're litigators and trial lawyers, we're business litigators, and we view every situation as a win-win. That's, I think, what distinguishes us and our firm is we approach it and say all of these disputes, every one of these business divorce disputes has a win-win. And when you approach it, you don't approach it like a legal matter, you approach it like what is the win-win, and you start driving both sides, and you force them to say, well, if you don't think this is a win-win, what's your idea of a win-win? And you start a business dialogue and start a business discussion. When you go to mediation, you take that same approach. Now, what we've also done is you get a mediation done, but there's a lot of issues in the mediation, and you're worried about things not getting resolved, and there are future disputes, which you've had post-mediation disputes. We make the mediator the arbitrator. If there are any disputes that arise under this mediated agreement, we go back to the same person who served as the mediator and have that person who sat through the whole day and listened to both sides, as long as we're happy with the mediation result we got, and we figure that person's going to be fair and we don't have to reintroduce a new judge or a new set of arbitrators to the problem, and we basically just go back to that person's office and we resolve the dispute there. So I'm not, again, saying it's a panacea, but some of the advantages of an arbitration, which I didn't mention also, are it's private. If you're a company and you really don't want the market to know about this dispute, the arbitration is all done in private. No one knows about the dispute. No one knows about the resolution of the dispute, and it's all kept private. The case is tried to an arbitration panel rather than to a judge, and then there is no right of appeal. Now, you can actually, AAA has a right of appeal process, but I've never seen anyone use it. I know it's been done, but we've never had anyone appeal. So it does get you the finality, which is the third leg of what an arbitration is supposed to achieve for you. So I was going to talk about early case assessment, and then Jason's going to cover these other. So what I mentioned was we take a different approach than I think a lot of trial lawyers do, which is resolving matters on a business basis. So there's something, you can go Google this online, and you'll see that there's a new trend. I've started seeing it within the past 5 years, but we've been doing it. We didn't know it was called this, but now it's called ECA, or early case assessment. So what is early case assessment? Early case assessment is saying when you have a dispute, either you're getting ready to file a suit or you've been sued, you look at the dispute and you say, I'm going to invest some resources in this. I'm not going to just start defending. I'm not going to just start filing an answer and just look at a few documents. I'm going to look at this dispute, and I'm going to hire lawyers who are going to come in and do a thorough case review to determine who are the key witnesses, what are the key documents, what's the key law at play here, and is this a case I need to resolve? Is this one I need to take to the mat, or is this a case that we need to get is bad? The witnesses are weak, they're former employees who are not happy with us, the documents don't tell the story, there's terrible emails. Find out it costs more money, but you do this at the beginning, and now you're more prepared than the other side going into it. So that's our view is the way you manage outside counsel. That's this sort of switching away a little bit from the initial topic of the exit planning, but it fits within it, which is how do you manage outside counsel if one of these things gets into dispute? You start with an early case assessment and invest resources in putting together your team on the inside, who's going to manage these lawyers, and then give those lawyers some rein to go figure out what the key aspects of the evidence are and the law that applies to that evidence, so you know the strength of your case at a much earlier stage than you figure it out as it goes on over time. There's a tendency to say, oh my gosh, it's not in the budget, I don't want to spend the money, so you start just doing things in the case and it drags on, and now you're 6 months into it and you still don't really know where you are because you really never invested the time and the effort to address your case at the beginning.
Just to cover these other briefly, fee structure just means considering alternate fees. If you are seeking to recover money, you should seriously consider contingent fee. I don't approve of risk shifting, but I like risk sharing. I want my client to have skin in the game, and I want to have skin in the game. I want to be paid for results, not just for cranking out and selling an inventory of hours that I'd like to unload on a client. And so having some upside for me, if there's money to be recovered, gives me an incentive to be efficient, but also to achieve a good result. And I think that helps align the interest of the lawyer. It's also good just to think creatively about fixed fees, flat fees, bonuses for getting the case resolved by a certain date, and think about how those affect the incentives, and look for lawyers who are willing to be creative in their fee structure and take some risk for actually achieving an outcome that's favorable, not just for cranking through the process. It's very easy to open up the lawyer playbook to page 1, get client, page 2, send large bills. And then instead, if you take the mindset of, I want the lawyer to have the same incentive as I have to get out of here, and I'm willing to let him have a higher return on his hourly time if he can get rid of this case, can be a good incentive structure and can help you feel like going forward that there's commonality there. Budgeting is an unpleasant process for lawyers, but I can't imagine many CFOs let many aspects of their business run without a budget. And so having the lawyers go through that exercise and then revisiting it regularly as the bills come in and you compare those to the variances can be a good disciplining exercise and forces the lawyers to really look at what they're going to do each month and each quarter on your case and be honest with you about how that's going to affect the cost, and then to revisit that and be accountable when those numbers either add up or don't. And that'll also give you a sense of, well, do they know what they're doing here? And then team, I think having regular communications in which you know what resources at your organization are going to be attached to this lawsuit, and having communications about that helps you manage the load on your employees and staff when they're asked to turn over documents. And rather than just have an uncontrolled process in which people are being pulled off the work that they're supposed to be doing to aid in the lawsuit.